all the matters, how much time? This is what? 1501 main matter.
1501 for judgment.
For the sake of clarity, following questions may be answered as under. Whether the provisions of the IBC would prevail over the Customs Act, and if so, to what extent? The IBC would prevail over the Customs Act to the extent that once moratorium is imposed in terms of Section 14 or 35(5) of the IBC, as the case may be, the respondent authority only has a limited jurisdiction to assess, determine the quantum of customs duty and other levies. The respondent authority does not have the power to initiate recovery of dues by means of sale confiscation as provided under the Customs Act. B. Whether the respondent should claim title over the goods and issue notices to sell the goods in terms of the Customs Act and the liquidation process has been initiated. Answer negative. On the above discussions, the following are the conclusions. Once moratorium imposed in terms of Section 14 or 35(5) of IBC as the case may be, the respondent authority only has a limited jurisdiction to assess, determine the quantum of customs duty and other levies. The respondent authority does not have the power to initiate recovery of dues by means of sale confiscation as provided under the Customs Act. 2. After such assessment, the respondent authority has to submit its file concerning customs duty operational debt in terms of the procedure laid down in strict compliance of the time period prescribed under the IBC before adjudicating the authority. In any case, the IRC, RC liquidator can immediately secure goods from the respondent authority to be dealt with appropriately in terms of IBC. Resulting in allow the appeal and set aside the impugned order and judgment of the MCLAT.
Next year.
15.1.
This matter is linked to the one that is just been pronounced already in CJI. In this case, 2 points of consideration was whether the sum number 2 the liquidator was justified in substituting the second Swiss challenge process for sale of part of the assets to the corporate debtor, where the appellant was declared as an anchor bidder and opting for a private sale process through direct negotiations in respect of the composite assets of the corporate debtor. If so, was the enclave justified in directing the respondent to the liquidator to restart the entire process of private sale after issuing an open notice to prospective buyers instead of confining the process to those parties who had participated in the process? We have analyzed the entire statement of office of the IDC and the enactment in Chapter 3 of which deals with the liquidation process right from the stage of initiation of liquidation till the stage of dissolution of the corporate debtor, and have concluded that the impugned judgment passed by NCLAT to the extent that it has modified the order dated 16 August 21 passed by NCLT and directed restraining of private sale processes squashed and set aside. In our opinion, the private sale process of the corporate assets of the corporate debtor should be taken further by the respondent to the liquidator without losing any further time, and we concluded at the earliest. All the eligible bidders who have made earnest money deposits would be entitled to participate in the negotiations to be conducted by the liquidator for privately selling the consolidated assets to the corporate debtor. The process of negotiations that commenced on 24th August 21 shall be taken to a logical end and not to a closure within 4 weeks from the date of past notice.
(1502) for orders. 1502 for orders.
Samal. The concern of the original petitioners and the monitoring committee merit due consideration of this court. Much good work has been done in the state of Karnataka because of the action initiated by the original petitioner and the subsequent judicial intervention by this court. In fact, it is this progress made steadily over the past decade that weighed with this court to even consider the relief regarding raising of the ceiling limit sought by the present applicant. The concerns raised by the original petitioner of possible over-excavation and its adverse impact on intergenerational equity must be balanced against the concern of the other parties, as the principles of sustainable development also comes into play. This court has generally accepted the recommendations of the CEC when it comes to the ceiling limit. In the present case, the CEC has recommended a complete relaxation of the ceiling limit, but we are not inclined to allow the same in toto. Rather, the situation merits a cautionary approach, keeping in view of the concern raised and to ensure that any changes in the situation with respect to the mining activity in the state of Karnataka is brought about gradually. We are of the opinion that the ceiling limit of iron ore mining may be raised from 28 metric tons to 35 MMT for district Ballari and 7 MMT to 15 MMT to Chitradurga and Tumkur districts collectively. Conservation of ecology and the environment must go hand in hand with the spirit of economic development, and fine balance between two goals is what is sought to be achieved even now. IAS 83141, 72931, 218 are disposed on the above terms. As far as the IA 10973 of 2008 is concerned, the same relates to directions to the CEC and the monitoring committee regarding deciding application for enhancement of the MPAP in terms of the earlier orders of this court. The same may be considered by the court on the next date of hearing.
Maybe this is a thing.
1503. 1503.
3D smart. The question raised in the present set of petitions relates to promises made by political parties for the distribution of free goods or freebies as a part of their election manifesto or during election speeches. The main contentions of the petition is that such pre-election promises, which have a large-scale impact on the economy of the state, cannot be permitted. The petition submit that such pre-election promises are being made by political parties without any assessment of the financial implication on the state is nothing but an attempt to attract the vote bank. This goes against the spirit of reasonable electioneering and is adversely affecting free and fair elections. This severely affects the level playing field between the different political parties. The money that is being paid by the taxpayers is ultimately being misused for political parties, candidates to gain or retain power. In this batch of petitions, there are two sets of petitions. The first batch relates to pre-election freebies, which may influence voters at the time of elections. The second set of petitions challenging the grant of benefits by the governments, which do not relate to any welfare measure or development activity, but rather are a ploy to capture vote banks. The land solicitor responded, and thereafter the election commission, additionally some other included respondents and all that. And ultimately, freebies may create a situation where the state government cannot provide basic amenities due to lack of funds, and the state is pushed towards imminent bankruptcy. In the same that we could remember that such freebies are extended utilizing taxpayers' money only for increasing the popularity of the party and electoral prospects. We have considered the issues raised in this batch of petitions from various angles, as well as the stance taken by the Union of India, Election Commission of India, and some political parties who have filed petitions before us. There can be no denying the fact that an election during the next round of the elections. It is also necessary to highlight herein the point raised by some of the interveners that all promises cannot be equated with freebies as they are related to wealth.